Can a court restrict your right to possess a firearm or a concealed weapons permit during the pendency of a criminal law case? Not if you've been sentenced, but if you've simply been charged and you're still presumed innocent in the process. When can a court say you can't possess a firearm or take away your right to possess a firearm? As a criminal defense attorney, I field this question a lot with clients of mine who are members of the armed forces or for whatever reasons have a concealed weapons permit, or members that are avid hunters, as I am, or people who are into the sport of firearms, or people who are just simply collectors, or have a couple around because they think it's appropriate for self-defense. And for whatever reason, the issue is mostly fairly clear in the court system when you're walking into it, although it's a very fact-specific issue. And I think the simplest, the clearest place where I can give an answer is if a firearm has been used or threatened or involved in the crime itself, and the court can prove it, or it can be proved to a court by either preponderance of the evidence or even by clear and convincing evidence, the court may or shall take away your right to possess a firearm during the pendency of the case. And the logic behind it kind of makes sense. If a firearm is involved in a criminal charge, and I stress criminal charge, well, it makes sense that the court will, or legislature, it makes sense that the legislature will tell the courts, hey, we don't want people possessing firearms till we know what went on because it's involved in a criminal law case. The other area where restriction is likely to surface is cases around domestic violence. And domestic violence is a term of art in the criminal law system. And what it really means is a close and personal relationship. For example, anything from roommates to spouses to ex-spouses to people you have children in common, people related to you by blood and marriage. These types of relationships. If a crime involves that type of relationship and there is assaultive and violent conduct or threatening behavior in it, a court will seriously consider taking away firearms in that setting, because the lethality index as it relates to these types of relationships is very high. People act on impulse and emotion, and if someone's been charged for being violent already in this setting, they want to take firearms out of the equation so no impulsive acts can lead to lethality, to lead to someone getting terribly hurt or killed during the pendency of a criminal law case. And I think the last situation where you really need to be aware of this issue is if you're charged with a very serious felony. My general advice to anybody that's involved in a criminal law case where there is a potential issue that a firearm could get taken away during the pendency of it is first beat the court to the punch. If you have firearms and ammunition, give it to your friends, give it to your family, and have them store it so that when you walk into court in an arraignment and the court asks, do you have firearms, you can comfortably say no in anticipation of this criminal charge. Your Honor, we had that distributed among friends and family. And what it will tell a court is that you, as a client and as somebody involved in this case, you're responsible, you're thoughtful, and you recognize the concerns that a court may have. And that action gives the impression that you're reasonable, and it makes a lot of sense. It also allows, when that kind of thing is said, that if possession is necessary for purposes of employment, it increases the chances, I think, of a court saying, well, this person is being reasonable in their personal possession, or is being reasonable from the court's perspective as it relates to personal possession. They're more likely to be lenient for purposes, in my experience, for professional possession. Something that should always go along with that advice is if you're going to have someone transport firearms and ammunition during the pendency of before a criminal law case, it shouldn't be the person who might be charged. You don't want to be caught with a car full of weapons and firearms when you might be pending a criminal charge. It's best if your friend or family does the transportation for you. So if there's ever a reason that the police sees it or is involved with it, it doesn't connect to the person who might be pending a criminal charge. So that's a kind of a very practical piece of advice surrounding firearms in general. As to the specifics of each situation, I have seen courts go out of their way to allow people to possess firearms for purposes of professional or for their work. depending on the facts of each case. If your case involves anything that I've talked about in this short video, you probably should talk to a lawyer in advance of your charges to make sure that you position yourself as well as possible to prevent the court from having to take the firearms. Or if your lawyer says, no, what, I think a court's going to take your firearms, you can pre-plan and make adjustments accordingly. I hope this helps. Thank you.